About once a week, our office gets a call from a family asking us to help them add their children to the deed of their house. We end up doing that for clients about 5% of the time that our clients make that request to us. And the reason is there are a lot of drawbacks to that approach. And this is a really, really important video that I hope gets the point across here. If you want to add your children to the deed of your home, you should do that if you want to do it, but you should only do it if you really understand all the pros and especially the cons of doing that. And I'm going to walk you through four really big drawbacks or reasons not to add your kids to your deed. First is taxes. This could cause undesirable tax consequences that we may or may not know about. This relates mostly to a loss of a step up in basis. That's a little bit too much to go into one video. I try and keep these videos under 5 minutes. That one would make it probably about 12 minutes total. I'm going to drop a link in the comments to a video on the step up in basis and why that's important. But just know here, there could be some, very well could be some unintended tax consequences that your kids are going to pay a lot more to Uncle Sam than you or they want. The second reason you may not want to add your kid or anyone other than your spouse to the deed of your home is about lawsuits. Once you add your child to the deed of your home, if they get sued and they get a judgment against them, the person suing them who won that judgment, called a creditor, can come after any property they own, with some exceptions that really depend on state law a good bit. But that property could very well be on the table for a creditor. That means you could be in trouble. And I don't know if we really appreciate this when we're adding people to the deed of our home. I'll add one small point to this, that in a state that has a really low homestead exemption for creditor purposes, like Alabama, ours is, I believe, $18,000. This is actually a really big deal. You could be putting your home in jeopardy to someone suing your son, daughter, sibling, or whomever. I also want to point out hidden creditors. That is, creditors that people don't think about. And the big one here is a divorcing spouse. A spouse in divorce proceeding is a creditor. They're suing you, and they're going to try and take what you own for them as the marriage begins the dissolution process. Do you want your son or daughter's former spouse trying to come after your house? Well, if you don't, then this might not be something that we want to do. So lawsuits are a big reason we're putting another asset that we own, our home, on the table for the co-owners, that is our son or daughter or siblings or whomever's creditors, to come after. I don't like doing that. Third is Medicaid. When we transfer assets and we are reasonably close to possibly needing nursing home care at some point in our life in the future, Medicaid is going to look back 5 years for transfers that were what they call less than fair market value transfers. That is gifts. So deeding your home to your kid, adding your child to the deed of your home, unless they paid you for full and valuable consideration, like the fair market value of the piece of property that you deeded to them, the whole thing, half of it, whatever, that's going to pose a problem, most likely for Medicaid purposes, if you need to go into a nursing home within about 5 years of doing that transfer. Those can be really hard to undo, and we really need to know what we're doing with that. Medicaid presents an issue with deeding property to children. The last drawback that I want to talk to you about adding your kid to your deed, is the loss of control. When I add my son to my deed, it is no longer just my property. It's mine and his. If I'm going to take a HELOC out on the house and pay for medical care or anything I want, just get the cash, I got to have his consent to do it. If I want to sell the property and go to California or go into assisted living or just sell the property because I want to sell the property, I can only do so with his consent. Now, some people say, well, my daughter and I, we're on the same page. And in fact, she's my caregiver, perhaps. She would never refuse to sign a deed like that. And I totally understand that. But think about a situation in which that co-owner, that son or daughter, dies before you. Their interest could very well go according to their estate plan, their will, their trust. If they don't have an estate plan, the state of Alabama's code has an estate plan for them. And it would go either to their spouse, their children, a combination of that, perhaps to you. The chances are low of that, but you're not in control of their estate plan. They can make a will without you knowing and put anybody in there. It says, when I die, everybody gets, or a certain person gets everything I own, gets this, that, or the other, gets the house that I now co-own with mom or dad or a sibling. So if that's the case, if your co-owner dies, the person you added to the deed, you could be co-owning this property with someone that you never intended and they never intended, and it could be a bad situation. These are 4 big reasons not to add your child or anyone other than your spouse to the deed of your home as kind of a band-aid, short and sweet style of estate planning, which is generally when we see this request made. If you need help seeing alternatives to adding your child to the deed of your home, give our office a call, 256-273-5109, or visit us online at thevalleyplanning.com. We hope you found this video helpful, and now you know why you shouldn't add your children to the deed of your home.